Good morning, my name is Rick Bell and I'm a real estate agent with Alain, Pinel, Realtors in Los Altos, and today I've asked Harry Price of the Price Law Firm to join me to go over some of the more common issues that he sees come up in real estate transactions. Good morning, Harry.
Good morning, Rick, and thank you for having me. I'm glad to be here. My law office is very near your office.
Yes, that's right. I'm on San Antonio and you're just across the street on Main Street. Anyway, the topic I thought we'd address is that often when you put on a property for sale, some of the neighbors tend to come out of the woodwork and they want to resolve some of the issues that have been festering between those two parties over time, and they see the sale of the property as an opportunity to bring that to the surface. I assume that's something that you see often in your business?
Yes, Rick, and that's actually a very nice way of putting it. A more sarcastic way of putting it is they come out of the woodwork because they view it as an opportunity to gain some leverage. They know, thanks to the internet, everybody who knows a little about your business, the duties of disclosure, and they feel that, a neighbor feels, whoa, if the for sale sign has gone up, if I notify the realtor, then the realtor wants to have a clean transaction. I'll get it resolved favorably because the seller's going to want to capitulate, if you will.
Yeah, that makes sense. And we've always thought of the three most important things in real estate are location, 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 but I guess that's become even more disclosure, disclosure, disclosure. Right.
It's a changing world. Everything has to be disclosed. Everything has to be, open and expressed. We can't just deal with assumptions anymore.
Yes.
Because otherwise the seller will be accused of whether it's intentional misrepresentation or negligent misrepresentation or failing to disclose. It's a very common thing these days as far as claims.
Makes sense. Well, why don't we run through some of the more common things that come across your desk? And it seems to me that one of the things that I've seen come up more often than not is property line disputes.
Right. We see a lot of boundary issues, especially in more semi-rural areas such as Los Altos Hills and what have you.
Right.
The fences aren't always on the property lines, and new buyers find that they might have a dispute with their next door neighbor. Oftentimes, though, it's the seller who's caught in the middle of wanting to sell a property, and then as you say, the neighbor comes forward with their claim saying that, oh no, the fence is what I've been using for so many years.
Right.
It should stay there.
And that can create other issues with encroachments, for example, right? Where everybody has assumed that the property line might be the fence and the house is built a certain number of feet from the fence, and suddenly you discover that the house is perhaps in the setback.
Right. And sometimes it's a house, sometimes an accessory structure. And if it's an accessory structure that's trying to be converted and you need to get permits for it, well, again, a neighbor might object, saying that it's one thing to use it as a garage, but it can't be living space, simply because of the fact that it's encroaching.
Right, that makes sense. Another thing that I think would come up frequently in the course of a transaction is a buyer that intends to use the property for future development. They're going to demolish it, it's a tear down, and they have ambitions for building a house of a certain size or a certain look, or maybe even two-story, and that can be an issue.
Right. We have a lot of wealth in our community, and new buyers frequently want to completely transform the property. One way would be to add a two-story building where there was a one-story residence, and that can also meet with resistance. As you know, some parts of our community have two-story overlays or one-story overlays where you can't build a second story, so that has to be disclosed too.
Mm-hmm. Yeah, that makes sense. What about maintenance sorts of agreements? So you might have a property, again, like in Los Altos Hills, that has a shared driveway. Maybe it's a flag lot with a shared driveway, landscaping easements where they share in the care and maintenance of that. What do you see out there coming across your desk in that regard?
Well, the first problem is if it's only a handshake agreement. A lot of these things are just oral agreements, we'll contribute when necessary. But then we get into disagreements of when is it necessary? Is it a repair, a maintenance issue, or is it an upgrade of the area, and who pays what? So sometimes it's just what should the look and feel be, what should the cost be, and then also what should the sharing of costs be. In a long driveway situation, like you're saying, a private lane, should the person at the end of the lane pay more because they're using the entire lane as opposed to the person at the beginning of the lane? And we see all kinds of disputes that you don't necessarily think of anticipating, but that's another good reason to consult with an attorney just to see what should be ironed out in advance.
So I think the issue here, at least within the context of what we're talking about today in a real estate transaction, is these tend to be the sorts of things that can fester amongst neighbors over an extended period of time, and then one side may ignore the other, or they may have no meeting of the minds on the topic, and it's the sale of the property that brings it to head, because a neighbor may think that they could insert influence at this point of time, which is actually correct. So from your view and how you get brought in, do you often find yourself really being a mediator, trying to avoid protracted litigation?
Many times. I think if a seller is wise, they've gone to someone like yourself who can tell the seller, as part of the listing preparation, we should talk to your neighbors. Make sure that we know all the issues, because neighbor issues can be a problem. It's when you get a seller who doesn't consult with someone such as yourself, who's aware of these issues, that problems develop, and then the seller's angry, and they go to an attorney because they don't want to be pushed around.
And this is post-close. So after the closing, they may say, "Hey, you had to have known this, and you suppressed it, and you didn't disclose."
Right.
And that's a much bigger problem at that point.
It is always, and so getting these issues aired and resolved, hopefully, in advance will be a cost saving to all concerned. And as far as, you're right about the role of mediation, that's what a lot of this is resolving conflicts between whether it's neighbors or others. And back to the other issue you mentioned about common problems with neighbors, it's not just private lanes or whatever, even people with shared backyard fences. Again, the look and feel. Somebody might want an open looking fence. Another person might want a completely closed fence as high as possible. So those things have to be ironed out too.
Right, and just thinking this through, particularly as it relates to redeveloping the site, there may be building criteria that is completely within the bounds of what's acceptable, meaning you can build a two-story house and you can build a house in the county that there's a lot of flexibility in what that can look like. So there may be a disconnect between what a party is allowed to do versus what they can maybe do expeditiously.
That's an excellent point, especially mentioning the county. Different communities have different building or zoning rules and regulations, and some people think that the county will greenlight anything, as opposed to their own city if they live in Los Altos Hills, or some other community. So it is good to know. I live on a street where there's 3 communities up and down the street, so you can't tell from just driving down the street.
So if, let's say, a selling party and a neighbor are in dispute, they've got a buyer, they're just not able to come to a resolution. There's just not a resolution to be had there. What, at that point, are sort of the general options in terms of taking the property subject to these claims, and as it relates maybe even to title insurance? We can talk about that.
Right. We have also a number of property buyers now that are buying all cash. They actually have a few more options available to them than the buyer who buys with financing. So, for instance, if a seller is fortunate enough to have a buyer interested in buying a property, where they're already in contract when an issue comes up during an escrow, and the buyer is paying all cash, the buyer can buy subject to that issue, whatever the issue is, even if it's an easement claim or an encroachment claim or what have you, with the idea that their title insurance might list it as an exception because they have actual knowledge of it, but that's okay. They'll close escrow. And once they close escrow, the buyer might feel, I'm taking away the leverage of the neighbor. Now we can resolve it, and we're more on equal footing, because it's not that he's frustrating a sale of the neighbor, it's that he's dealing with this new neighbor.
Yeah.
If, on the other hand, though, a buyer needs financing, any institutional lender wants a clean policy of title insurance. No claims, no issues, what have you.
So there's certain things that could rise to a level like encroachments or easements that really impact the property that a title company might list, and a lender would say, you need to resolve that before moving forward.
Right. Of course, there are also some surprise things that are actually listed of record, such as certain easements, that still cause a surprise downstream. So those even need to be more fully disclosed. A seller, when listing a property, can have the title company give a color-coded plat map, tract map, to explain where the location of the easements are. And just to give you one example, I had a property dispute where, after the close of escrow, the buyer wanted to put a large kennel in his large backyard. As soon as he put the foundation for the kennel, he got a knock on the door from PG&E. That was going to be placed right over an underground gas main pipe that cannot be built upon. The buyer had no idea. So even though he got a title report saying there are easements, and one of them was PG&E, he would have assumed they were only on the perimeter of the property, not right through the middle. So he couldn't build a pool there, or a kennel, or anything permanent.
And if they, in this particular case, if they had read the title report quite closely, it would have been evident?
Yes and no. Yes, it was disclosed. There's let's say, an easement recorded in the 1970s, but it doesn't tell you the location unless you get a color-coded map.
Okay.
And then, unless you actually read the easement, it might not have told you that this is an underground gas main pipe that can't be built upon, as opposed to a PG&E easement just for overhead wires or something like that. There's a big difference.
I can only imagine that gave a few people, including the real estate agent, a little indigestion.
Right. It resulted in litigation. No surprise.
No mediation in that particular case.
It wasn't successfully resolved that way, and so it went all the way through a trial.
Well,
worst case scenario, as they say.
It happens.
Right.
Well, listen, Harry, I think this has been really productive today, and we've covered some good ground, and hopefully people viewing this will find it interesting. One thing I think it's important that we remind our viewers here today is that legal and financial matters are complex. They're subject to interpretation. They can change at any time. And so anybody considering a legal strategy really needs to consult independently with their own legal counsel on this matter and not rely upon necessarily our discussion today. So
excellent point. That's a case-by-case analysis. Every case has different facts, different issues to address.
Excellent. Great.
Right.
Well, listen, Harry, I appreciate your time today, and maybe we'll have you back and do this again on a new topic.
All right. Thank you so much.
All righty.
Appreciate
Thanks
it.
a lot. Bye-bye.